Each year, Microsoft Research hosts hundreds of influential speakers from around the world, including leading scientists, renowned experts in technology, book authors, and leading academics, and makes videos of these lectures freely available.
Started a little bit late. Let me welcome all of you to this talk today. I'm really proud to be able to introduce Kevin Cathcart, who is the Executive Director of Lambda Legal Defense. He's been the Executive Director since 1992 and is a leading strategist and spokesperson in the movement to achieve full recognition of the civil rights of lesbians, gay men, bisexuals, and transgender people, and those with HIV. Before he joined Lambda, he was at GLAAD, which is in Boston. This was the Gay and Lesbian Advocates and Defenders. And with that, let me turn over the mic to Kevin.
Literally, he's going to turn over the mic to Kevin. Thank you, Dan. And thank you all for joining us today. I'm very happy to have the opportunity to talk both about the work of Lambda Legal and just in general about the state of the LGBT civil rights movement. Obviously, this is let's make sure this table's going to hold. This is obviously far more topical than we dreamed it would be when we scheduled this some time ago, what with last week's decision of the Washington State Supreme Court in a case that had been brought jointly by Lambda Legal and the Northwest Women's Law Center. And also there was a sister case that had been brought by the ACLU. Both of these were cases that we had won at trial about 2 years ago. We've been waiting a very long time, almost 2 years, for the state Supreme Court to release the opinion. And I have to say, never have we waited so long for such a disappointing set of opinions to come down. So I'm sure we will talk about that. But I wanted to give a little bit of an overview both about the state of the LGBT civil rights movement in this country right now, and some more specifics about the broader work of Lambda Legal. I'm going to try very hard, although this is challenging for me, to speak briefly and have a lot of time for questions. At some point I will just stop and open it up for questions because speaking briefly is not my forte. So just a little bit of overview about where we stand today, because I think it ties in one important part with the good news from Washington State, and I do worry that the good news from Washington State has been eclipsed in a big way by last week's news, and I want to make sure that people keep it in mind, which is that earlier this year, after a very lengthy 30-year battle in the legislature, Washington State became the 17th state in the country to have a statewide anti-discrimination law that provides protections that may not seem critically important to people who are living in the Seattle area or who are working here and who are not worried, as I presume none of you are, about losing your jobs if you're lesbian or gay or bisexual or transgendered. But I assure you that outside of the bubbles that many of us live in, there are many, many people across the state who need the protections of this statewide civil rights law. Lambda Legal is a national organization. We're based in New York, and we have regional offices in Chicago, Los Angeles, Dallas, and Atlanta, and we have what we call help desks in all of our offices. We have 800-number hotlines for all of these, and people call looking for information, looking for assistance with legal problems that they're facing around sexual orientation or HIV status. And we get over 5,000 calls a year collectively at all of our offices. In the western region, Washington State is second only to California in terms of the number of calls that we get. And in all of our offices, the largest number of calls we get are about family law issues generally concerning children, adoption, custody, that kind of thing. But consistently for years now, the second largest number of calls we get are about employment discrimination. And so I can't overstate how important it is for states to have broad statewide protections around employment, because it is clear from the calls that we get from all around the country that this is a key issue for many people in our community who really fear that they would lose their jobs if they were out, or who have lost their jobs for being out. And we've represented many people in employment discrimination lawsuits. So it is a wonderful tool to have, and I think it's also important to remember that the passage of a law it's been a 30-year process. A lot of people have been involved. I'm sure many people in this room have been involved. And I think frequently there's a tendency to think, oh, we passed the law, that's over. And I just want to assure you that when you pass the law, it's not over. When you pass the law, that's the beginning. Because now we have a really important tool that the lawyers can use to protect people statewide. And it's a very, very important beginning. So the legislative piece, the lobbying piece is over, but it's going to help move things forward for a lot of people across the state. And I think one of the other things that's really important about having things like employment protections on the books is if people are afraid that they're going to lose their jobs because they come out, it stifles them. They can't participate in community. They can't participate politically because many people feel like they have to protect their jobs. Same thing is true if people worry that they're going to lose custody or visitation with their children. There are things that people prioritize, and so they can't be politically involved, whether it's around issues like marriage and relationship recognition or any other kind of community work, political or non-political, because they're afraid. The same thing is true for people who are in the military who can't come out because of the current military policy. They are cut off from community in so many ways. So when you have employment protections on the books, you make it possible for far more people to be part of the community, to raise their voices, to weigh in on a whole range of issues. And so, again, it's a beginning, not an end point, and it's a very important beginning. And I just hope that, as the disappointment over last week's decision begins to settle a little bit, and as we figure out what the next steps are on all of that, that people continue to be proud of the fact that Washington State still is a leader, because by far the majority of states do not have statewide laws. Regardless of how long it took, it's on the books now, and we need to move forward with that. The other thing that's very hot right now, Washington and nationwide, is, of course, partnership recognition. And we had been very hopeful that we were going to win at the Washington State Supreme Court. We did not. Cue up the music. And we had a terrible decision from the New York State Court of Appeals, which is the highest court in New York, the week before last. It was actually such a poorly written and poorly reasoned decision. It makes the bad opinions out of Washington look like legal scholarship and poetry. So if you are embarrassed to live in Washington right now because of the decisions that came down last week, believe me, I'm much more embarrassed to live in New York than you could ever hope to be, because those decisions were quite terrible. But there are a number of other marriage cases pending around the country. New Jersey, for example, where we expect a decision from the state Supreme Court within the next 5 or 5.5 weeks. As people probably know from the experience of Washington in the last year and a half, it is a bad idea to try to predict when courts are going to issue decisions, because there were more sort of false summits on this. Oh, it'll come out in November. Oh, it'll come out in January. Oh, it'll come out in March, and it never came out, and it never came out. In New Jersey, I actually feel fairly confident about predicting that we will have an opinion in the next 5 weeks, because the Chief Justice of the New Jersey Supreme Court is retiring in September and will not be sitting when the court resumes hearing cases in the fall. And there is no way that she is going to retire and leave this in some box in the corner of her office. Things left undone. Let's issue a ruling on the marriage case. So usually it's hard to predict when these things are going to happen, but in this case, I think it's very clear that a decision has to come down. Right now, of course, Massachusetts is the only, yeah. Yeah, oh, sure.
You'll probably come to it, but I'll ask now.
Uh-huh.
So I'm curious if you're going to get to sort of the rhetoric around gay marriage issue, and specifically, we have an anti-discrimination law. What is the rhetoric for keeping marriage operating without the stigma of this?
Well, sure. The question was about the rhetoric of the arguments, primarily the arguments against marriage. I guess the question is in part about the language and tone of the court decision, or the arguments going forward.
Yeah, but if you have an anti-discrimination law, and I'm a bit out of it.
Mm-hmm. Well, let me say that the anti-discrimination law does not cover things like marriage. So it is possible to have an anti-discrimination law on the books and not have any form of relationship recognition. In fact, that's true of the vast majority of states that have anti-discrimination laws. There are 17 states now that have anti-discrimination laws on the books. There are, I guess I would say, 6 states that have some statewide form of relationship recognition. Massachusetts has equal marriage rights for same-sex couples. Vermont and Connecticut have civil unions, which are effectively almost exactly the same thing as marriage, but by another name. California, Hawaii, and New Jersey have very strong statewide domestic partnership laws. The California law is really no different than the civil union laws in Vermont and Connecticut, and basically grants all of the rights that the legislature is able to grant. The big challenge with all of these is there is a federal called DOMA, the so-called Defense of Marriage Act, that was passed about 10 years ago on the federal level, which prohibits the federal government from recognizing marriages in any of the states and gives states the option of choosing not to recognize marriages from other states or jurisdictions. And I'm talking now primarily just about the United States, but of course, in Washington we share a long border with Canada where same-sex couples can also get married, and there has been a lot of movement in some European countries, most recently and probably most surprisingly Spain, which has gotten out ahead of most of the United States in relationship recognition. So I guess I would say in terms of anti-discrimination laws and relationship recognition, they're on very different tracks. There may be some parallels there, but they're on very different tracks, and you could have equal marriage laws in a state that did not have employment protections. That's less likely than having employment protections in a state that doesn't have marriage protections. But in terms of the kinds of arguments that were made, one of the things that was interesting in the New York decision, and now it's done a little more subtly, but it's also in the Washington State decision, is as the court has tried to come up with reasons to restrict marriage to opposite-sex couples, they've painted this very curious picture of sort of heterosexual sexuality and relationships, and have said, well, the legislature could find that they wanted to restrict marriage to heterosexual couples because they have the capacity to procreate, and they also have the capacity to have, I wrote down some of the language earlier. There were some great lines. I'm not going to find it in my notes here. Basically, it's sort of like a hit-and-run theory of heterosexual sexuality, that you have to give them an inducement to stick around and raise children, and that makes sense to restrict marriage. And what I find fascinating about this is that the state Supreme Courts of New York and Washington are now accusing heterosexual couples of behaving in the way that society has traditionally accused gay men of behaving. And they've also turned it around and said, however, when gay couples decide to have children, it is a conscious decision. They enter into it with a lot of thought and planning, so they don't need this extra inducement to behave themselves, because we can just sort of trust them, but we have to provide. It's the weirdest argument. If somebody had predicted several years ago that the courts would be making these arguments, and if you're interested in this, you really should take a look at the New York court decision, because it's sort of the crudest and crassest laying out of this argument that I've ever seen. I don't know that I've ever seen a state Supreme Court decision that's so pathetic, but that's also so on the surface, and that they weren't ashamed to put this out. It is one of the few times when I read this that I thought, I wish I was a law student now. I've never wished I was a law student ever since I was a law student. I didn't wish I was a law student then. But it would be wonderful to be a law student now, because law students are just going to have a field day for the next several years skewering these opinions in law review and journal articles, because they was just set up to be knocked over. And I can't believe that they didn't see this coming and that they've left themselves in this position. Now, that's the kind of small consolations that people on the losing side say, now we'll make fun of them. Nevertheless, they won, and we have to carry on in other states and continue trying to get Massachusetts to not be the only state. Massachusetts, for a little over 2 years now, has sort of been alone out at the end of a long limb, and it is not the best place for them to be. It also doesn't provide protections for people in the other 49 states because Massachusetts has this unique statute that no other state has that restricts marriage in Massachusetts to people who are Massachusetts residents for same-sex marriages. So we can't go from Washington State or Massachusetts or Kansas or anywhere else in the country to Massachusetts to get married. If we win in New Jersey, and I still have high hopes of winning in New Jersey, no guarantees because I had high hopes of winning in Washington State. If we win in New Jersey, the borders will be open just as they would have been in Washington, just as they will be if we win ultimately in California, where the case is before the mid-level appellate court, or in Maryland, where the state Supreme Court has just agreed to hear the appeal of a trial court decision skipping the mid-level courts. In any of these other states that are in play, there are no residency requirements, and that means that as soon as we win in one of those states, people are going to go from all over the country. There's no question about that because there's a lot of pent-up demand. We saw this in San Francisco a couple of years ago. They're going to go, they're going to get married, they're going to go home, and that's when it's going to get really interesting because they're going to go home just as opposite-sex couples have done for years. They can go to whatever state they want. People get married in Florida or Hawaii because it's warm, or they get married in the place where they went to college, or they go back to the place where they grew up. You don't have to live in the place where you get married. But when opposite-sex couples go back to Washington, for example, or back to New York, they're considered married. So what we're going to be facing is a situation where lots of people are going to go and cross state borders, get married, come back to where they live, and present themselves as married, and then that is something that not only their governments are going to have to grapple with, but their employers are going to have to grapple with. I think of this as the Full Employment Act for lawyers for all time to come, because the potential for lawsuits is going to be staggering. And it is only a matter of time before one of these other states opens up, and this is what we're going to be seeing. But I want to, before I stop and break for questions, I do want to talk a little bit about the range of work that's going on, because I feel like it is critically important to talk about marriage, to talk about the decision, talk about what's going to be happening going forward. There's also a little bit of a problem in all of this, that because of the New York decision and the Washington decision so close together, sort of marriage is all that anyone talks about, and a person could come to a conversation like this or read the newspapers and think that it's the only issue on the LGBT civil rights agenda, and that is so far from being true that I just want to make sure that we get everything out on the table. At Lambda Legal, we have 9 major issue areas that we focus on. The first is relationship recognition, and part of that is marriage, some of that is civil unions, domestic partnerships, and other kinds of employee benefits plans. The second area, which is very big, as I referenced earlier, we get the most calls at our help desks about our parents and children. Custody, visitation, adoption, second parent adoption, a whole range of ways in which families make or unfortunately sometimes break family bounds. And the law varies dramatically across the country about states that allow second parent adoption, states that don't allow second parent adoption, states that recognize the rights of unmarried partners to continued relationships with their children after a breakup, and states that do not recognize these. So there's a huge amount of work that's going to continue to happen on that going forward. The third area is workplace discrimination. I also talked about that a little bit earlier, and the prevalence of workplace discrimination nationwide, which continues to be an enormous problem. We have a focus on youth and schools that has 2 main pieces to it. This is one of the reasons I talk at great length, because I say, well, I have 9 things, and then each one has A, B, C, D, and E. So actually, I'm about to talk about 50 things. Can you hear me? I can try. Let's do it this way. How's that? So in our youth and schools work, there are 2 main areas to that. One is about violence, because there is still a significant amount of violence and harassment that takes place for openly gay kids in junior high schools and high schools. And one of the good things that's happened as a result of the movement and visibility and work in recent years is that many young people are coming out at earlier and earlier ages. And in many ways, that's a wonderful thing. But it also puts young people at greater risk, because they're frequently then still living at home, still attending public schools. They have less control over their lives than used to be the case if people waited till they were college age or out in the workforce. And so it sets people up for greater risk. So there's a lot of violence in schools. The sort of counterside to that is the incredible growth in organizing by young people in schools and GayStraight Alliances, which have sort of taken off and now exist in thousands of high schools nationwide. And we do a lot of work in supporting young people who are trying to organize GayStraight Alliances in their schools. There is a wonderful piece of federal legislation called the Equal Access Act that was actually passed by conservatives in Congress some years ago with the purpose of making sure that young people in schools were allowed to organize religious organizations in their schools. But it says that schools that allow student organizations can't discriminate on the basis of the content about these student organizations. And so it's actually a wonderful thing to be able to take that law, sort of turn it around and use it to argue, and to argue successfully, that if schools are allowing any kind of extracurricular student-led activities, the chess club, the French club, whatever else they have in schools, they have to allow GayStraight Alliances to exist. And this really has been settled law now for several years, although we just had a new case that we settled a few weeks ago in Chicago, where a charter school in Chicago decided that because they were a charter school, and charter schools are exempt from certain regulations by the state, that therefore they decided they were exempt from this federal law and they did not have to allow the students in the school to create a GayStraight Alliance. That was not true. The law covers charter schools as well, and that case was just settled, and it is the first precedent covering charter schools. Every time we have one of these cases, I think, well, this has got to be the last one because this is settled law. And I say that again and again, this is settled law, this is settled law, and each time there is some new twist and we have another case, but happily each of these cases comes out the right way. And I think that if I talk about the school stuff for a minute, that this is the area that's going to have the most impact long term on the overall civil rights struggle, because GayStraight Alliances do not just impact the young people in the high schools who are members of the GayStraight Alliances. In fact, that tends to be a very small number of people in most schools. It doesn't even include most LGBT youth in those schools who are frequently too nervous or afraid or whatever to participate. But the beauty of it is that it makes GayStraight Alliances and the clear presence of gay people in schools become like background noise or wallpaper or something in these schools, so that whenever there is a listing of school activities, the French club meets on Thursdays at 4, the chess club meets on Tuesdays, the GayStraight Alliance meets on Wednesday afternoons, whenever those announcements are made over the loudspeakers, try and think back to a horrible time in your youth and those scratchy loudspeakers were announcing all of these things, it becomes background noise for everybody in the school. So it doesn't just affect the young people who are going and getting support there, or the young people who, for whatever reasons, are not going but are feeling a sense of support just by knowing that it exists. It affects everyone in the school by making it clear at very young ages to people that LGBT people are part of their peer group, are part of their community, exist in their school as they do everywhere else. And I think that that is what contributes to changing attitudes among young people. Switching back to the relationship recognition stuff for a moment, whenever polling is done about people's attitudes towards equal marriage rights for same-sex couples, if you break it out, the demographic data by age group, what you find is the older people are, the less support there is for equal marriage rights, and it just moves like a beautiful bar graph right down the line. The younger people are, the more support that there is. And polling data of young people, say ages 15 to 25, shows overwhelming support for equal marriage rights. And it is one of the reasons why I am very optimistic about this work going forward, because the people who are 15 to 25 now are going to be 16 to 26 next year. And, you can do the math. They keep moving forward. Every year, more and more of them are eligible to vote, are involved in their communities in a different way. They're no longer high school students or college students or whatever. And I see no reason to believe that their attitudes are going to change, nor do I think that the attitudes of the people younger than them who are moving up into the 15 to 25 demographic are going to change. And so 5, 10, 15 years from now, the overall polling data is going to be tremendously different because many of the people in the 75 and up category are no longer going to be polled, and many of the people in the currently 5 to 25-year-old range are going to be, sort of entering their prime time as members of community, hopefully as voters and participants in the political process, and that's going to be very good for us. So that's one of the reasons why we think the schoolwork is so important, in addition to the fact that no one should be beaten up in school because they're lesbian or gay. No one should be harassed in school, and that our young people in schools have as much right to community and support as anybody else. We also have a foster care project that focuses on young people in foster care. We created this after we began doing a lot of work on schools when we realized how many young people, particularly LGBT young people, were not even in schools. And again, as a result of people coming out earlier and earlier, there are more and more kids who, when they come out, are kicked out, run away, or thrown away by their families and their schools because it isn't safe, because their families are not supportive. They frequently end up in foster care systems. Unfortunately, many foster care systems are just not equipped to handle having large numbers of LGBT youth in them. They don't have the policies, they don't have the training, they don't have the sensitivity. Foster care system is the safety net. There's no safety net beyond that. So if kids bounce out of the foster care system because they find that unsatisfactory or unsupportive, that means they end up on the streets. And that is a terrible thing. LGBT youth are disproportionately represented not only in foster care, but very disproportionately represented on the streets. And we think it's very important that we try to create the conditions to both keep them in their schools and their homes, and if that doesn't work, to have them in safe foster environments, whether it's individual homes or group homes, that are equipped to deal with them so that they don't end up on the streets, because if they end up on the streets, then they often end up survival sex and at high risk for HIV. They drop out of school. It's almost impossible to stay in school and live on the streets and support yourself, and so much for a future. So, and since this disproportionately impacts our community's young people, we think this is very important. We do a lot of work on transgender issues and also on HIV legal issues, and I will lump these together. They're very different, but what is similar about them in both of these cases, the bulk of the work is employment discrimination and access to medical care. There are other things that come up around the edges, but over and over again, people are fired from their jobs because of their HIV status. People are fired from their jobs because they are transgendered. People are denied appropriate medical care because of their HIV status. People are denied appropriate medical care because of their status as transgendered. And so there's an enormous amount of work still to be done on both of those issues. We have a Latino Outreach project called Proyecto Igualdad that focuses on making our materials and our information available to people in Spanish-speaking communities. Latino communities are the fastest growing communities in this country and are communities that are going to come, I believe, to great political power in the coming decades, and we think it's very important that the mainstream LGBT movement begin reaching out to and making connections to these communities now, because if we wait, if you wait till people have a lot of political power and then you go say, hi, I just wanted to introduce myself, that is probably not the best way to create working alliances. And there are many LGBT people in Latino communities where there are fewer resources because most mainstream LGBT organizational resources are just not that widely available. So this is something we've been focusing on for the last couple of years. And then finally, we have a judicial fairness campaign called Courting Justice, and probably this will resonate with people right now because I think nothing is more important for our community than having fair and independent judiciaries. And this is true on a federal level where we have been involved with other organizations in battles around Supreme Court appointments, but it is absolutely as important on the state level as it is on the federal level, and I think the events of last week should show that. One of the problems with the marriage lawsuit in Washington State is that there was a change in the makeup of the state Supreme Court between when the case was filed and when the case was decided, and it was a one-person change that made all the difference in the world. In fact, Judge James Johnson, there's two Judge Johnsons on the court, and a third one running this year, so it's going to get very confusing to talk about the Washington State Supreme Court in the near future. But Judge James Johnson has been quoted in the newspapers as saying, well, if I wasn't there, gay people would be getting married in Washington State today. And this may be the only thing that Justice Johnson and I agree on. If he wasn't there, same-sex couples would be getting married in Washington State today. After that, I think we disagree on absolutely everything, including whether the sun is up in the sky. But that is very true, and I think there's a couple of important pieces to that. One is that as a community, we need to pay attention to the politics of the judiciary in states where judges are elected. In New York, judges are appointed by the governor. We need to pay attention there to the politics of the appointments, because those appointments can make all the difference. The same thing is true in the federal courts. And something that people in Washington State should also, I think, pay particular attention to. There is a bill pending in Congress to split the Ninth Circuit, which is the federal court circuit that covers the entire West Coast. There's a bill pending, and I think there will be hearings later this month or in September in the Senate to split it into two. Now, the Ninth Circuit has always been the most progressive circuit of all of the federal court circuits. I think this is retaliatory on the part of the people who are proposing it. They want to cut the circuit, well, they call it in half, although the half is interesting. It becomes California, Guam, the Marianas Islands, and a couple of trust territories I never heard of before would be the Ninth Circuit. And then Oregon, Washington, Alaska, Hawaii, Montana, Idaho, Arizona, and I think New Mexico, I'm not sure, would become a new 12th Circuit. And if a new circuit was created, the current administration would get to appoint all of the higher-level judges, because there are no higher-level judges. It doesn't exist right now. They would be appointed all at once, and we would have a very conservative 12th Circuit, and you all, I presume most of you live in Washington, you all would be living right in the middle of it. So this is really an enormous attack, I think, on the independence of the judiciary to start carving up districts and putting all of these new judges in place. And I encourage people to pay attention to it. Lambda is not a political organization. We don't lobby. We don't endorse candidates. But we do pay attention to what's happening with the courts, because that's obviously critical to our work. And this will have an enormous impact on the civil rights of anyone living in the boundaries of this new district for many years to come. And this is not important only for LGBT purposes. It's important for a whole range of purposes of things that go to the federal courts. So that's kind of an overview of the kind of work that we do, and mindful of the time, because only one person was brave enough to interrupt me, I want to just pause for a minute and see if people have questions. And if you don't, I'll just start up again. So I encourage you to ask them, because it's much more interesting if I answer the questions you really have than if I try to guess what they are and talk. So here and then there. Yeah?
How much will the decisions in the Washington Supreme Court and New York Appeals Court affect other Supreme Courts in other states like New Jersey?
Well, that's a good question. The question was, how much will the decisions from the New York Court of Appeals and the Washington State Supreme Court affect other state Supreme Courts like that in New Jersey? I'm actually confident that the New York Court of Appeals decision will have no impact whatsoever. I have fantasies that it will have actually a good impact by driving people in the other direction, because it is so pathetic that no one will want to be associated with it in any way whatsoever. But it is not the kind of decision that I expect will be cited in any meaningful way. I think it will be cited in lists, but it doesn't have the reasoning that is going to sway anyone's opinion. I think the decision from Washington is a little more challenging because it was a little better written, and therefore, although I don't think it holds up to really like the harsh light of day, it was a little better written, and therefore it can be used by other courts. I don't think it's going to sway anyone. I think it can be used to kind of buttress decisions that have already been made. And so, every time there is a bad decision, it's not just that we didn't win, but that it is ammunition on the other side. I think a lot will become much clearer in the next 6 weeks or so when we have a New Jersey decision, because if it is as good as I hope it could be, then we'll have an answer to that question that we like. And if it turns out to rely on Washington State, I'll be very surprised, but that could happen. And so, yes, there is a real concern there. I think, that one of the good things about the Washington case, And, you know, I'm definitely in the business of making lemonade right now because I don't have a lot else to work with. There was a headline in the Seattle Times, I think it was, last week, right after the decision came out, that I cut out and saved, but it's back in New York, so I have to see if I remember it properly, that said, 9 justices, 6 opinions, no consensus. And I actually think that headline, it was a brilliant headline because it summarized pages and pages and hundreds of pages of writing, because for 9 justices to write 6 separate opinions, and one of them was only 1 page long, but the other 5 were substantial, all substantial pieces of work, shows just what a fragmented issue this is. And if it's a fragmented issue for the court, that's reflecting something about how the court sees the issue in society today. The fact that there is so little consensus, in fact, there was only 1 opinion that was signed on by 4 judges, and that was actually what I think of as one of the good opinions. That wasn't the lead opinion. The lead opinion was signed on by 3 judges, and then there was a second opinion signed on by 2 that made the 5-judge majority. But on our side, the first opinion was signed on by all 4 judges, and then there were 2 other. Some of those judges wrote independent opinions explaining further their thinking on the subject, and some of those are very good. Justice Fairchild and Justice, I didn't used to know her name, and I don't know, starts with a B, wrote actually excellent opinions that I really would recommend to people to take a look at. Justice Bridge, because I think they really named what the issues are. And you know, one of the big issues in this case, and we see this all the time in courts, courts are accused of, you know, being results-oriented. It all depends on how you frame the question. The best example of this probably is the difference between the Bowers decision at the U.S. Supreme Court and the Lawrence decision just 3 years ago. These were the sodomy cases at the U.S. Supreme Court. In 1986, when the Bowers case went up, the court framed the question as, is there a deeply rooted constitutional right to homosexual sodomy? Well, even I'm not going to argue that there was a deeply rooted constitutional right to homosexual sodomy that you could find in the United States Constitution. So by framing the question in that way, they answered the question. And the question was, you know, then they could say, no, we looked, we couldn't find it. Some years later, when an almost identical case went up, Lawrence v. Texas, which was decided in June of 2003, this was a Lambda Legal case, they had matured and the court had changed and the society had changed and it had trickled up to the court. And this time they framed the question as, is there a right to privacy under the United States Constitution that allows consenting adults to make individual decisions about their sexual activity? And that's a much easier question because it's a right to privacy case, not a right to homosexual sodomy case. So now, and I think we see this very clearly in the decisions of the Washington State Supreme Court in the marriage case, if you ask the question, is there a right to homosexual marriage under the Washington State Constitution, the court is going to say no. If you say, is marriage a private matter in which adults should be allowed to make their own decisions and that's protected by the Constitution, the answer is much more often going to be yes. And the difference between the majority opinions and the minority opinions were completely in how they framed the questions. And there's actually a lot more back and forth in these opinions than you often see in state Supreme Court decisions where it's like they clearly each wrote their opinions, they traded them, and then they each rewrote them attacking the other one, because there's the main opinions say a lot about Fairchild's and Bridges' opinions. Fairchild's and Bridges' opinions say a lot about the majority opinions. It was really, I don't know how many drafts must have gone back and forth for this to happen. But it's really even named in some of these opinions that it is about how you frame the question. And that's what we need to do, is continue working on how the question is framed in society at large, because that does trickle up to the courts. Okay, you and then you.
So I was curious if you could characterize partnership relationships or coordination that you do with the ACLU, or contrast perhaps, like, do you guys segment what you go after in terms of
The question was, how do we sort of divide up or work with the ACLU and other organizations on the relationship cases. And actually, this is true of a whole range of cases. The main legal organizations in our community, which are Lambda Legal, the ACLU Lesbian and Gay Rights Project, Gay and Lesbian Advocates and Defenders, which is in Boston and focuses on New England, and the National Center for Lesbian Rights, meet twice a year for what we call our legal roundtables, and have been doing so since 1985 to coordinate strategies, to talk about plans to avoid reinventing the wheel on a regular basis. And depending on the cases, there are cases that we co-counsel, as we co-counseled Anderson with the Northwest Women's Law Center. There are cases that we file briefs in each other's cases. There are cases where we divide up the map geographically and say, okay, the ACLU is going to do, as they are right now, Maryland, for example. GLAAD is going to do Connecticut. We're doing New Jersey. There were 2 separate cases in Washington. It's a whole range of things, but there is a lot of coordination and discussion between the legal staff at the organizations about how to best use the resources we have, which are very limited to the amount of challenges that we see and also the amount of opportunity that's out there, so that we're not kind of bumping into each other trying to do the same cases on the same courthouse steps. Yeah, back here.
After the Washington State Supreme Court decision came down, our governor, Gregoire, issued a statement in which she seemed to advocate the idea of separating religious marriage from civil marriage. And since then, some newspaper editorial boards have picked up on that. The Walla Walla Union Bulletin, for example, advocated the same thing. And there's been a lot of blogs and letters to the editor and talk radio calls, those kind of things, where it seems like there is at least a body of people out there that think this might be a middle ground that we could go to as a society. And so my question is, what do you think of the concept of allowing the churches to have ownership of the word marriage, government, whatever this institution is called, civil unions or something else? I think civil unions is kind of tainted as a term because for a variety of reasons, but let's just use that term for the time being. Governments have civil unions, but they apply to everybody, regardless of sexual orientation. So whether you're a same-sex couple or whether you're an opposite-sex couple, when you go to the government, you get a civil union. And if you want it to be called a marriage, you have to go to a church to get that. Would that be, do you think, a reasonable approach?
I think it has a lot of, at least theoretical, attractiveness or charm to it. I don't know how difficult it would be. You know, in this country, unlike, say, in Europe, and I think one of the reasons why some of the marriage debates in Europe have gone more smoothly than here is because there has always been a much clearer divide between the civil part that is done with the government and the religious part, which, if it is done with the church. In our country, it's been much more like this for a very long period of time, and I'm not sure. I would agree that untangling those things would be a good thing. I don't know how. And I would not have a problem with whatever we wanted to call it, we'll call it civil unions, if it applied to all people. The problem that I have is, say, in a state like Connecticut, which has marriage for heterosexual couples and civil unions for same-sex couples, and then says, oh, but don't worry, they're all the same thing. And I think, well, you know, if they're all the same thing, let's call them the same thing. The concept of separate but equal, I thought, had been discredited a long time ago, albeit in different circumstances, but I think the reasoning still holds. And that's the challenge that we're facing now. I don't know, though, that is entirely necessary, because although many people in this country don't think that the two are separate, they actually are. You can get a civil marriage in this country, a heterosexual couple. You can go to City Hall, get a license, get married. You can be married by a judge. Lots of people are married by judges. You can, if you choose. You know, our government kind of deputizes religious organizations to act in its stead in a way that in Europe is not done. In Europe,
Some people object to that, too.
And some religious people object to that, as well as some less religious people. But it is so ingrained in our culture that it is hard to get people to separate out that their marriage license was actually something that came from the state when their wedding was something that took place after walking down a church aisle. And it just, you know, we haven't done a good job of separating those things out. But I think we could separate them out even without a complete changeover. although it would take a massive amount of public education, and this is a tough issue because it's stuff that people grew up on, and they went to weddings when they were little kids, and all of that stuff that is kind of set in people's minds, so you can talk kind of till you're blue in the face. I say all the time, well, actually, we have civil marriage, and this is different, and people go, hasn't budged them one bit. So I don't know how to make that happen. But I think it's always important to remember, and I'm glad of the question because it gives me a chance to emphasize it here, that what we're talking about at Lambda Legal in our cases or the ACLU's cases or whatever is civil marriage. We are not talking at all about what religions choose to do or not to do. And there are many religious bodies now that will do ceremonies or blessings or whatever, and there are many that, as far as I can tell, will never do ceremonies or blessings. And I don't have an opinion on that because it's not my role to judge whatever there are people who are active in various denominations who have strong opinions about those things, pro and con in many denominations. But that's not the legal issue. The legal issue in this case was about the state of Washington or King County issuing civil marriage licenses equally to all people. And so anything that would help kind of untangle that, I think is a good thing. It was a nice suggestion by the governor. I don't know that she has a plan for how to do that, and I don't know that anyone has a plan for how to do that. And I think one of the things, though, that's been interesting in recent years is that there have been some more voices, it's hardly a chorus at this point, but some more voices coming out of religious communities saying, we don't want to be entangled with the state on this. Sacraments are sacraments. The state is the state. We're in the sacrament business. They're in the license business. And I think maybe if there were more voices from religious communities making that argument, because my making that argument isn't going to convince the people who are sort of deeply involved in the tangle of it. I think it has to come from the faith communities. And there's been a lot of organizing, I will say, in faith communities in various places around the country about equal marriage rights. And that almost automatically brings us to that question and causes the ministers and the rabbis and the various people involved to take positions on that. Yes, in the green.
Well, given the next steps for us for marriage or civil union in Washington seem to be legislative, is there anything else that's going to be done or could be done through the judicial branch in the state to help this cause, or is at this point that part of the fight over with?
No. That part of the fight is definitely not over with. I'm sorry. Oh, the question was, let me see, whether the courtroom side, the judicial side of the fight is over with, and is this now solely a legislative battle in Washington State, or is there anything left on the court side? And absolutely there needs to be political activity in the legislature, because it didn't work with the courts at this point, and we need to go to the legislature. I believe that a bill will be introduced later this year in the Washington State legislature. Now, let's be realistic. It took 30 years to pass an employment discrimination bill. I don't think it means it's going to take 30 years, because I think the world is moving faster, particularly on LGBT equality issues. But, I'm thinking of a number bigger than one, let's just say, when I'm trying to peg the number of years here. So it's not going to happen in any immediate way. I think, and this is very initial thinking. The decision just came out last week. The organizations haven't all met. There have been many initial discussions, but I wouldn't say that it has all been thought through and hammered out yet. And in fact, if I thought it had all been thought through and hammered out in 1 week, I would have to say I would think we weren't doing a very good job of thinking it through. It should be a longer process. You shouldn't make these decisions in the first couple of days when everybody's going like this. But I do think that the court left potentially some big openings for future cases, not for marriage, the whole civil marriage piece that we were originally going for, but about things like benefits. Now, and many people thought that the court was going to, if they didn't rule favorably on marriage would at least address these issues, and it's kind of the gaping hole you could drive a truck through in these opinions, that they did not deal with it in the way that, say, in Vermont in 1999, which was a marriage lawsuit that led to civil unions. The court ruled that the legislature had to do something. They could have passed they could have equalized the marriage law. Instead, they created the civil unions law. The court said they had to do something to treat people fairly in terms of benefits and state recognition of relationships. Even the lead opinion in the Washington case, probably what I thought was the best paragraph in the entire thing was this fairly detailed articulation of the burdens, the legal burdens that fall on same-sex couples and families because the state does not recognize these relationships. And it really was a very good list. I might have added a few things or changed a few words, but I have to say they captured the essence of it very well. And to have that list in this lead opinion was very interesting. And so many people think that the court was in a certain way inviting further litigation, not about marriage, but about some of these pieces. And that is something that we and other legal organizations are looking at very closely. One of the things that I find hopeful about this situation is that it was a 5-4 vote. It seems very clear to me that if there were to be litigation about the incidences of marriage, as it's sometimes called, about insurance or benefits or whatever, we're not going to lose any of the 4 votes that we had for the big picture. So you actually only have to change 1 vote of the 5 in order to change a 5-4 to a 4-5. So I anticipate, but this is not a guarantee, it's early, it's only been 1 week, and we're still figuring this out. I do anticipate further litigation, which I hope will happen in concert with work in the legislature. Well, right now, sure, the question is to what degree is work in the legislature going to be hampered by people waiting to see what the courts are going to do? Is that a fair rendition of your question? I actually think that most people in the state right now, because of the sort of strength of the opinion, the way it's been reported, I don't think most people are thinking there's a lot of hope in the courts. So I don't think that's going to interfere. I think as a community, we do need to think more about operating on multi-tracks at the same time. This all your eggs in one basket thing, we might have some evidence that it doesn't always work that well. It's just a theory.
Well, in general, the committee chairs in the state legislature will put their foot on a bill if they think the courts are going to rule on it. They won't let it go through.
Right. But it's certainly clear that the courts are not going to rule again on marriage. They may rule on some pieces, but they're not going to rule on marriage. So if there is a marriage bill, and I think a marriage bill is probably the most difficult bill to move forward. A civil unions bill is easier than a marriage bill because you get away from the semantic thing that causes people to go like this, and domestic partnership is easier than, there's a lot of gradations, and maybe Washington will think of a new name because civil unions was just created in the year 2000 in Vermont. Before that, it was not a concept in this country. So I don't think that the potential for some pieces of legislation are necessarily going to slow down. What I've already said, I think, is going to be a very slow process in the legislature. And I don't think we should wait. I think that we need to really think seriously about moving forward with multi-pronged approaches. And I also think people have to keep in mind that the landscape could change dramatically. I mean, the New Jersey court could rule tomorrow. And if they rule in favor of marriage, the whole landscape changes, and people don't pay that much attention to what happened in New York 2 weeks ago. It's ancient history. The world moves very fast. If they don't rule for a while, or if they rule against us, it's a different thing. But there are enough states in play that things could change dramatically from 1 week to the next. I don't really anticipate they're going to rule tomorrow, but I do anticipate they're going to rule in the next 4 or 5 weeks. So, we don't know. By the time the legislature is really in session in the fall, we don't know what's going to be going on. And certainly, I don't anticipate any action in the Washington State Legislature. I don't even know if they're going to meet, but let's say not till after the primary, and then I would say not till after the November election. That's just the nature of state legislatures. Okay. And by then, there will absolutely have been a decision in New Jersey from the state Supreme Court. There might be a mid-level court decision from California. Maryland will at least have been scheduled, perhaps argued, not decided yet. So you know, things are moving very quickly. We're not talking about, you know, how do we create a 5-year plan for a very static environment, because a lot of things are happening. One little story, we're about to be out of time, except I've got lots of time if people have time. I don't know. I was told to wrap up at sort of by 2:30, and it's 2:29 by the clock in the back. The courts in New York and Washington, for example, both went out of their way to say, this is a matter for the legislature, not a matter for the courts. And I will just point out that last year the California legislature passed a marriage law that would have equalized marriage in California for opposite-sex and same-sex couples. It went to the governor, who said, this is not a matter for the legislature, it's a matter for the courts. So there's a little bit of which wherever it is, somebody says, not me. It's like a game of hot potato, I think, of like, let's toss it to the other people. And I think a multi-pronged approach in a state like Washington makes it, yes, it's true, it could make committee chairs say, well, we don't have to work on this because it's happening over there. But since right now everybody's already trying to toss it to the other person, even if the other person isn't in the game, I think having everybody in the game would be very helpful. I can't repeat that question, but you'll just have to figure it out from my answer. I think that the language of this court decision is such that if the legislature were to pass a marriage bill, it would be very difficult for the court to find that unconstitutional in any way, because almost all of the opinions, not James Johnson's opinion, but the lead opinion, which was signed by 3 people, including the Chief Justice, go out of their way to say more than once, if the legislature or the citizens were to pass this, they have the authority to do so. So I don't worry here. I worry about, you know, how long would it take to get the legislature to pass something. That's something real to worry about. But if the legislature were to pass something here, I don't worry, unless it was terribly drafted in some bizarre and overbroad way, and we would hope to work with whoever was drafting it to make sure that it didn't look ridiculous right from the word go. I don't worry about that being overturned, because I think enough of the justices, at least of the current court, now the court could change with every successive election. I think there's 3 justices who are up for either re-election or not, depending on what happens in the next round, and I don't know when the next election is after that. But if you have anything that looks remotely like this court, enough of the justices, 7 of the justices, are very clearly on record as saying the legislature or the citizens have the right to change this law. So it would take a substantial change in the court, I think, for that to be a risk. Do you have a question?
I do. I was wondering if you could talk a little bit about how do civil rights issues affect or not business and the business landscape?
Okay. The question was, how do civil rights issues affect or not business and the business landscape? Well, one of the things I think is most important on that topic is to recognize that business, at least many major businesses in this country, and certainly in the high-tech field, have been far ahead of government in how they recognize and treat LGBT people. So we see businesses leading with domestic partnership plans, with anti-discrimination policies, even in advance of laws. And obviously this is not true of every business in the country, and there's a difference between the high-tech fields and the gas companies, and, you know, certain things like that. But we have seen a lot of leadership from major corporations in this country, and I think that's been very important and has been very helpful in moving government forward because it desensitizes the issue in the same way that I think, it's not part of your question, but I'll just go here, that having local ordinances, city or county ordinances, even though they don't have the strength, the kind of enforcement teeth that state laws could have, are actually very important building blocks in getting state laws, because whatever state, we'll use Washington as an example, the more that counties or cities or major employers in the state already provide certain kinds of protections, the easier it is for the legislature to then vote them into effect statewide, because significant numbers of people are already protected, and because they're not worried about a backlash from the business community, and they do worry about the business community, and sometimes they're under pressure. I mean, we're here, we've seen it go both ways, I guess, in recent years, but they are often under pressure from the business community who, in many fields, see the existence of anti-discrimination laws and good employee benefits programs as being key to their ability to recruit and retain the kind of talent that they need to have in their workforce. And we've seen just in the last year, in some of the states that have had constitutional amendments, anti-marriage or anti-gay constitutional amendments on the ballots, there have been statements by business leaders in various states saying, you know, this is going to be bad for the business community in Minneapolis, St. Paul, in Indianapolis, in different places that have been fighting these battles, because they know we're going to have a hard time convincing talent to come here because they don't want to come to a place that seems regressive and in which they're going to be unprotected when they might have the option of taking a job in California or Washington State or New Jersey or New York or wherever. So I think the leadership from business continues to be incredibly important, particularly because so much of big business is, you know, so multi-site. I'm not even getting into multinational because that's beyond Lambda Legal's scope. But within the United States, it's very important for businesses to have some consistency, and I think that's going to play an important role, particularly as the relationship stuff is very unsettled, a real patchwork across or among states. Businesses can't operate well with a patchwork. If they have employees in Massachusetts who are married, and they have employees in California who have domestic partnerships, and they have employees in Connecticut who have civil unions, and then they have employees in 12 other states who have nothing, and they want to be able to move people around, and the people in Massachusetts say, you know, I'm not going to Oklahoma. I'm just not. And, you know, so there's, I think, the need for consistency actually pushes businesses towards advocating for more balanced policies across the board, and I think that those are very important voices. And I would encourage, if there are people here who have a role in the business voice here, it is an important one that could be used to great advantage and should be, because it's very different to have business leaders talking about the need for coherent, fair national policies than to have gay rights activists talking about it. It's heard differently by a different audience. So I think it's very important.
So let's go ahead and thank Kevin, and if any of you would like to stay on to ask him some more questions, I'm sure you could.
I've got time, so I'm here for a while. And thank you all.